Hello friends, I hope you all are doing well, taking care of yourself and your family by remaining at your home, following the government regulations on COVID-19. Well, now let's start with the topic that we left in the last lecture. Up till now in module 1 we have dealt with the concept of minimum wages and the provisions related to the same in Code on Wages 2019. The concept of payment of wages we had started with, and we are done with the introduction and historical development part of the same. So starting with the definition, important two definitions for this concept of payment of wages, and then the allied provisions on payment of wages in the Code on Wages. So there are two definitions that we have to focus from for this particular concept in the Code on Wages. One is the definition of establishment under section 2M of Code on Wages. The term establishment is being defined. It's being defined as any place where any industry, trade, business, manufacture or occupation is being carried on, and it includes government establishment. What it says that the establishment would be considered as any place where any industry is established, or any trade is being established, or any manufacturing process is being going on, or any business is carried on. It would be considered as an establishment, and it even includes the government establishments. There is one case, Tamil Nadu Water Supply and Drainage Board versus MD Vijay Kumar. The citation and abbreviation is 1991 ILLJ 26MAD. And this is a judgment of a Madras High Court, wherein the court had to determine whether the board which was created by the government of Tamil Nadu for the drainage water, whether that would be considered as a board which is fulfilling the definition of the establishment, and by virtue of that if it has to follow the provisions related to the payment of wages. It was an act earlier, right? So the Payment of Wages Act 1936 for the workers who are working within this board. The question was determined by the Madras High Court in a way that yes, the functions of or the objectives of this board for which it was created was actually fulfilling the definition of industrial establishment, because it had to carry some process, and it was a kind of industrial process and involving certain other aspects as well. So it was held that yes, this would be considered a board which is established by a government for the drainage regulation and development of the drainage water as well as the drinking water, would be considered as an industrial establishment, and they have to fulfill the definition or the provisions related to the payment of wages. Now the second definition, which is very important, is again this is important from both the part of both the concept of minimum wages as well as concept on payment of wages. The definition is the definition of the term wages. Section 2Y defines wages. How it's being defined is the term wages is being defined as all monetary remuneration which are payable to any employee when at the completion of the employment or terms of employment would be considered as wages under this particular act. Under this particular code. Now this even includes the salaries and allowances and otherwise, and the inclusivity of the wages is being expanded by adding that it includes basic pay, diurnus allowance and retaining allowance. So basic pay is, as we all know, that what is a basic wage, a basic remuneration that is being fixed by the employer and employer with maybe kind of negotiation or any other way. And then the due allowance for retaining the employee, or for appreciation of his work other than the bonus, employers also pay something called due allowance. So that due allowance is either 2 or 3 or 5% of the basic pay. And then retaining allowance, to retain the employees there are certain allowances which are paid by some employers. So the definition of wages under the Code on Wages says that it would even include basic pay, due allowance and retaining allowance. So all remunerations which are payable to an employee by the employer at the completion of the terms of the employment would be considered as a wage. However, there are certain things or certain kinds of payments which are not considered as a part of the term or the definition wages. The first one is bonus not forming part of remuneration under the terms of employment is not considered as a wage. So if in case under the terms of employment you have not formed or you have not negotiated or you have not formed bonus as a part of the remuneration, it will not be considered as wages. Now there is a case on this. It's a case of 1975. The case is of Gopalan versus Agmati Chit Fund. Now in this case, the question was whether the wage would include bonus. Now it was held in this case that the Bonus Act 1965 was enacted and it has made bonus as a statutory right, and there is 8.33% of the bonus that has to be paid to the employee by the employer. So it was held that since it's a statutory right, and since there has not been any amendments or in the Payment of Wages Act at the time in 1975, it was held that the bonus would be considered as a form of or as a part of the wage. Now this definition is also not going against this particular decision. What this clause says that wages doesn't include bonus which is not forming part of a remuneration under the terms of employment. So if under the terms of employment, if there is nothing called bonus, if it is clearly mentioned that no bonus shall be paid, or maybe if it is clearly mentioned that any bonus shall not be paid other than whatever the statutory requirements are there, so then in that case such extra bonus other than what has to be paid as a statutory bonus will not be considered as a part of the term wage. The second is a value of any house accommodation or the supply of water, light, medical attendance or any other amenity which is being excluded by the order of the government. If the government has, appropriate government, either the center or the state government, has excluded this value of house accommodation or the light, water or medical attendance to form part of the wage, it would not be considered as wage. Now why such notifications would come from the government? Because in certain cases employers would rather exploit the employees by stating that, see, I am also paying you value of your house accommodation, I'm also paying you light and the value of medical attendance, the water and everything. So your wages, your wages is inclusive of all these things, and hence employers would pay lesser remuneration to the workers. So the governments will take a call that no, all these things would not be considered as a part of a wage and shall not be considered as the something which is fulfilling something which is part of the definition of the wage.